Good afternoon. My name is Richard Williams. I'm a policy executive at the SRA. Welcome to today's QASA webinar. The purpose of today's webinar is really to bring people up to speed on the changes to the scheme since the fourth consultation exercise and as a result of the ongoing policy development work we've been doing at the SRA. I think there's about 300 of you sort of logged in at the moment, so we'll try and make as much time for questions at the end. If we don't manage to answer your specific question, we have got them all logged and we'll do our best to collate them and put together a sort of Q&A document and put it up on our website. So for those of you who are not familiar with the QASA scheme, I just wanted to give a quick background. The origins of the scheme lie in the 2006 Lord Carter's report, which called for a more proactive approach to assessing the quality of criminal advocacy. The joint advocacy group was then established, which contains representatives from the BSB, IPS and ourselves to take forward the development and design of the scheme. The key, a critical point in designing and developing the scheme has been the public interest. The JAG group has been, it's been really important that we keep that central to our thinking alongside our regulatory objectives. The current status of the scheme is that it's been approved by each individual regulator's board. It was approved by the SRA Board on April the 24th. If you go to the SRA website, you can access those board papers as they were. It was a public decision. The package of papers to approve the scheme is now with the Legal Services Board. You may or may not know that they have issued an extension notice in terms of making that decision. That's due to the size, complexity and scale of the QASA scheme in its entirety. This has led to a delay in the publication of the scheme handbook, which was due to go live on the 17th of June. We're led to believe that this delay will not cause a significant delay in the launch of the scheme. It's very much on track. QASA applies to those advocates undertaking criminal advocacy. JAG has developed a definition of criminal advocacy, which you can see on the screen now. This has now been finalised as part of the consultation process. This definition pretty much means that local government solicitors or those who are undertaking specialist criminal advocacy are excluded from that definition and therefore will not need to enter the scheme. The next few slides summarise the core components of the scheme. The scheme is based on a single common set of advocacy standards which apply to all advocates undertaking criminal advocacy. We expect for our regulated community that those standards will apply across the 4 levels of QASA. There is indeed a 5th level, 4QC, but for our regulated community we pretty much think that there will be people registering at those 4 levels. Advocates will be expected to be accredited at one of those 4 levels. The scheme has an inbuilt progression route built into it, and advocates can progress subject to high rights of audience through those 4 levels by demonstrating through assessment that they meet the required standard for the next level. That assessment and accreditation will be by one of 3 means, depending upon which level you enter the scheme. For level 1, it will be through assessed CPD, and I'll come on to talk a little bit more about that later. For levels 2 and above, for levels 2, it will be by assessment organisation, and for levels 2 and above, it will be by judicial evaluation in a live trial. This table categorises the cases involved with QASA, and they are graded to a specific level, and advocates accredited at each of those levels will be able to undertake the work involved at that particular level. Again, this has now been finalised on the back of the 4th consultation. All advocates will be required to re-accredit at their current QASA level every 5 years. Re-accreditation, as I've mentioned before, will be by assessed CPD assessment or organisation or by judicial evaluation. Progression is voluntary, It'll be up to you to decide, depending on how confident you feel or whether you're taking on new responsibilities, whether to progress within the scheme or not. Progression is by assessment, organisation or judicial evaluation, depending upon the level in which you are operating at. So this slide hopefully summarises the link between QASA and high rights of audience. The implementation of the scheme will not result in solicitors losing their high rights of audience. I think that's really a key message we want to get across. Solicitors who currently have high rights of audience will be eligible to enter the scheme at level 2 or above. Solicitors with high rights but who do not intend to undertake trials for whatever reason can enter the scheme as a level 2 trial capable advocate. This will enable the individual to undertake non-trial work at level 1, 2 and 3. Solicitors who have attained their high rights since 2010 will be automatically accredited at level 2 trial capable. So at the point in which you're required to register and you've obtained your high rights since 2010, we will automatically accredit you as a level 2 trial capable advocate. Now, this is in recognition of the fact that you've recently undertaken your high rights assessment, and also we want to avoid really double charging advocates in terms of assessment. If you are a trial capable solicitor, you can progress to take full trials by undertaking judicial evaluation. We asked last year those advocates intending to undertake criminal advocacy to notify us of their intention to do so. Just over 10,000 advocates notified us, and that information has been absolutely pivotal in supporting the planning and development of the scheme. So we'd like to thank you for all of those who took the time to notify us of their intention to do so. I thought it might be worth just going through a few slides to sort of break down that community a little bit and give you a picture of what the QASA community looks like. In terms of advocates entering the scheme, the vast majority of solicitors will be entering as a level 1 advocate, and as you can see on the screen there, the figure's around 70%. Obviously, as we move up the levels, the number of solicitors entering or planning to enter the scheme decreases. In terms of gender, the male-female split is broadly consistent with our overall regulated community, with sort of slightly fewer females and slightly more males than that community. In terms of ethnicity, again, broadly consistent with the regulated community, with marginally more Asian and black solicitors planning on joining. And I think it's important to bear those figures in mind as we look at some of how we've mitigated the potential unintended consequences of the scheme in some later slides. Just over 1% of advocates who notified indicated a disability, and of that disability, visual impairment. Those advocates with visual impairment were the largest group. The scheme has been subject to 3 previous consultations, and as you can see on screen there, they were the topics covered. The 4th consultation was launched at the back end of last year. The consultation covered numerous elements of the scheme, including visions of the scheme, the revised guidance to how the level of a case is set, the competence framework, and the contents of the 2-year review. That consultation period was supported by a series of stakeholder engagement events. And again, we'd like to thank everyone who took the time to participate in those stakeholder engagement events and who responded to the consultation. We received 348 responses, and again, you can see how those responses were broke down. In terms of the barristers and chambers responses, 200 of those were simple one-line emails agreeing with the Criminal Bar Association response or a particular circuit response. We've worked on the basis that essentially there's 148 substantive responses to the consultation. The consultation and our ongoing policy work has therefore resulted in what we're calling 3 major policy changes. The first policy change involves the extension in the time period allowed for the collection of judicial evaluations required to enter the scheme and re-accredit within the scheme. There is very strong feedback as part of the stakeholder engagement event and the consultation that the initial proposal of only allowing 12 months to collect the required judicial evaluations would act as a barrier for some advocates to enter the scheme. This is because the practice patterns of some advocates mean that they can only undertake a very small number of trials within a 12-month period. There is decreasing availability of trials and an increasing number of trials that are undertaken by recorders. We've listened to that feedback and we've taken it on board, and what we've now done is extended that period in order to obtain the judicial evaluations from 12 to 24 months. So once you enter the scheme, you've registered, you then have a period of 24 months to obtain the required judicial evaluations. In terms of progression, the 2-stage progression will still retain a 12-month period. The second policy change involves the harmonisation in a number of judicial evaluations required to enter, progress and re-accredit within the scheme. The original proposals this time last year for the scheme were set that advocates would be required to obtain 3 competent evaluations from 5 effective trial opportunities. Again, the feedback was very strong. We listened to that and sort of came to the conclusion that, given the climate around the availability of trials, we needed to reduce that and ensure that there was a consistent approach to the number of trials required across the scheme. So it's moved from 3 down to 2 competent evaluations from 3 effective trial opportunities. Hopefully this is clearer and more consistent for advocates whilst they're in the scheme. The third policy change really involves the re-accreditation for those advocates who are intending to come into the scheme at level 1. The original proposal stated that level 1 would be by assessed CPD and through assessment centre. We've done a significant amount of work to try and understand the impact on those advocates intending to join the scheme of requiring advocates to attend an assessment centre at level 1 in order to demonstrate their competence to be re-accredited. This work has identified a disproportionate cost impact on some groups of solicitors, in particular those solicitors from a Black and Asian background and particular age groups within those ethnic groups. Clearly, as a regulator, an outcomes-focused regulator and trying to implement a scheme that's in the public interest, having a requirement that requires advocates to attend an assessment centre with a disproportionate impact is not in anyone's interest. So we've revised our thinking regarding that, and we'll be adopting a flexible approach to re-accreditation. So by flexible, we will be setting some parameters in which advocates can re-accredit, and it will be by a number of routes. For example, advocates will be able to demonstrate their competence through a portfolio approach. It may well be that advocates can demonstrate their competence through an online assessment, and we'll be issuing guidance prior to launch around re-accreditation requirements at level 1. The stakeholder engagement exercises and the consultation did identify a number of benefits of QASA. The first of those is that it will increase stakeholder and wider public confidence in the quality of criminal advocacy. Particularly from the solicitors community, there was a feeling that everyone is assessed against the same standards regardless of their education and training pathway, and many believe that this may be a way in which solicitors and barristers, there may be some parity between those in terms of perception. The structured QASA offered a very clear pathway through the scheme, and progression is very much in the control of the advocate, and QASA will not fundamentally change the practice patterns or daily working lives of advocates. There was a sense that, you know, if you accredit and then you stay at a particular level, you don't have to do anything apart from reaccredit 5 years later. We've undertaken 4 equality impact assessments to date to support the development of the scheme. These are contained in one aggregated document that has been submitted to the Legal Services Board. So if you go to their website and look under current applications, you should be able to find our aggregated equality impact assessment. We're committed to the ongoing assessment of impact. That process doesn't stop now. The scheme has been approved by the board. It is ongoing, and again, stakeholder engagement will be critical to that. I wanted to spend the next few slides talking about how we, as a regulator, will try and manage some of the adverse impacts identified through the quality impact assessment process. The first, and I think key issue, is around the perception from solicitors that judges will be biased in favour of barristers and will be biased against individuals from equality groups. This is something the SRA takes incredibly seriously. We've worked very hard at JAG level to ensure that we've put in place mechanisms which enable us to identify instances where this may happen, but also manage those. The first approach we've taken is that only those judges that have attended the City Law School training will be able to assess an advocate in a live trial scenario. The training has been delivered, a number of training sessions have been delivered. The take-up from judges is high, and as part of that training, they will consider things around equality and diversity, avoiding bias, and making evidence-based evaluations. Each judge, on completion of training, will be given a unique identifier. That unique identifier will be on every case. They make an assessment against an advocate, and obviously when we receive the case from the advocate themselves, we'll be able to look at that. So the IT infrastructure to support the scheme will be able to house all of those cases, and we'll be able to undertake regular sampling of forms completed by judges to identify any trends in the way in which they mark advocates or particular group of advocates. That situation applies within the SRA, but it also applies across the JAG group. So we'll be able to look at how judges have marked advocates from the bar and from our regulated community. Where an advocate has serious concerns around the marking of a judge or feel that they may be subject to bias, then at no cost to the advocate, we can call on a pool of independent assessors who will go out and almost double mark the judge in the live trial setting. We think those approaches will give the mechanisms and hopefully some reassurance to advocates that we are managing bias, and where it has been identified, there are situations and processes which we can adopt to ensure that it doesn't happen again. The scheme requires assessment by different judges. This issue is slightly less now, given the fact that we're only looking for 2 competent evaluations from 3 effective trials. However, for some advocates, particularly those in rural areas, obtaining evaluation by 2 different judges may present a barrier to them entering the scheme. As I mentioned before, we have had a high sign-up by judges. That may not always be the public perception, but the figures of those available judges to sign up are well into the high 90s. Again, if an advocate is struggling to meet the scheme's requirements, we can call on a number of independent and external assessors to support the advocate. So where you can only access one judge, you can contact us and we can arrange for an independent assessor to provide a second marking in one trial opportunity. Again, we think that is an approach which will reduce the impact of advocates struggling to obtain evaluations by different judges. At level 2, accreditation will be by assessment centre, and this has raised a number of concerns from many parts of our regulated community, and there's a number of issues related to the use of assessment centre. The first one is the perception that if you're accredited by assessment centre, your accreditation is somewhat deemed less than by judicial evaluation. We don't believe that in any way, shape or form. Assessment centre, accreditation to assessment centre will be robust, rigorous and against all of the competencies for that particular level. In terms of reasonable adjustments, we will ensure that where necessary and appropriate, assessment centres make the required reasonable adjustments in order to allow advocates, for example, with a visual impairment, to undertake the assessments. A number of solicitors have been concerned around the accessibility of assessment centres. Where will they be provided? Will there be an adequate geographical spread? When will they be provided? And again, these are key concerns which we are very aware of and which we take seriously. We will ensure that there is a widespread geographical coverage of assessment centres and ensure that they are open and available at all times to take account of solicitors' practice patterns or their caring responsibilities. A number of solicitors have been concerned that should they have to take a maternity leave or an extended period of break away from the profession, that they will be negatively impacted by the QASA requirement. Again, we hope that this can be managed through two ways. Obviously, being accredited for a period of 5 years allows you to sort of dip in and out of the profession, for example, to go on maternity leave. Your accreditation will still be running in the background. We will offer an extension process as well. So where advocates are struggling to meet the time frames involved with the scheme, for example, obtaining the judicial evaluations within 24 months, advocates can contact us and we can arrange for an extension to that period in order for advocates to meet the requirements of the scheme. There's been criticism of the QASA scheme, a number of criticisms. One of those is in terms of that it will be too administrative and too bureaucratic. Again, we've worked incredibly hard to ensure that this isn't the case. The system, which is in development and very near completion, will be online. It will replicate your experiences of my SRA in terms of the look and the feel and how you interact with it. Having an online system ensures that we can try and maximise efficiencies across the organisation. It means we don't have to have staff in place to manage the administration of the scheme. It is done online and it's done automatically. For example, the K form will be assessed automatically within the SRA. This approach means that we can reduce the costs associated with the scheme. The slide that you have in front of you are the proposed and indicative costs of meeting certain parts of the scheme. So these are indicative. They're based on a cost recovery model, and again, they are based on an online system in order to reduce the back office functionality required here at the SRA. We will be finalising these costs and making them public nearer to the launch of the scheme. So in terms of next steps, those dates there you have on screen outline the registration dates. The first phase is the 30th of September to the 9th of March 2014. An extra month has been granted to take into account recent MOJ consultations. This period applies to those advocates who intend to practice within the Midlands and Western circuits. The second phase is the 10th of March to the 13th of June, and this applies to those advocates intending to practice in the South Eastern circuit. In terms of numbers and where advocates are located, the notification exercise allowed us to sort of understand the flows of numbers, and by far the largest area is obviously the South Eastern circuit. I think out of the 10,000 advocates, it was way over 7,000 will be registering in phase 2. The third registration phase is from the 30th of June to the 3rd of October, and it applies to those advocates intending to practice in the Northern, North East and Wales and Chester circuits. Registration will be an online process. Unfortunately, we're not at a stage where we can give you screenshots at the moment. However, it will be online. Advocates will be asked to self-certify the level at which they believe, in accordance with the scheme handbook, they will enter the scheme. You will then have 3 months. You'll have 3 months to register, and once you have registered, you will then have, depending on what level, 24 months from the date of the SRA granting provisional accreditation to move to full accreditation. So if you're intending to enter the scheme at sort of level 1, on completion of the registration process, you will actually be fully accredited. For the other levels 2, 3 and 4, you'll have to go away and seek judicial evaluation in order to be fully accredited. We will issue guidance on registration closer to the point. The 2-year review has been integral to JAG's thinking. This is a review aimed to enable the regulators involved to assess the operational efficiency and the impact of the scheme from the opening of the first registration phase. The review process will enable us to make an assessment as to whether the scheme continues to promote regulatory objectives, it guarantees standards of criminal advocacy, and it continues to be in the public interest. Importantly, the review period allows us to obtain information regarding the equality impact, any equality impacts that may have resulted from the implementation of the scheme. In terms of more information, there is more information available on the SRA website and the web address there. We intend to increase the available material on that site as we get closer to registration in order to allow advocates to fully navigate the scheme's requirements. And again, this will be happening over the next few months. There is a further webinar planned in October, just the day after the opening of the registration period, which will be aimed specifically at those advocates from the first registration phase in order to help them understand registration. There is a QASA email address there, and it is monitored daily, so if you do have any queries, please feel free to drop us a line and we can work through your particular query. We're going to take a short break for questions now because we've had a significant number. So we, for a couple of minutes, just going to kind of gather a few thoughts and then could come back to you with and start answering some of those. we've had a significant number of questions, so we've been sort of working through and trying to identify some common themes. So for the rest of the session, we're going to work through some of those questions. We've had a question from Neil, who's asking, what will level 1 reaccreditation actually look like? At the moment, we are adopting a very flexible approach to it. We will set a number of different approaches to the way a level 1 advocate can reaccredit. Those approaches are likely to involve demonstration of the competencies required for level 1 accreditation by a number of methods. For example, it may well be by demonstration through portfolio, it may well be by peer-to-peer review, it might well be by attending some online training. I mean, the key issue with level 1 reaccreditation is that we've tried to liberalise the approach as much as possible in order to reduce any disproportionate cost impact on essentially the biggest group of solicitors within the QASA scheme. So we think this sort of very flexible approach will allow advocates to meet the reaccreditation requirements a lot more easily. John has asked a question regarding advocates who practice all over the country. Again, we know from the notification data this does actually apply to quite a number of advocates. The guidance around registration will be prior to the launch of the scheme. Will very much focus on getting advocates to think about the areas where they conduct the majority of their criminal advocacy, and that will be used as a basis in terms of the phase in which they are registered. And once they're in the scheme, clearly the QASA accreditation is kind of a national one, and you can use it the depth and the breadth of the country. Fiona's asked a question around the status of newly qualified solicitors in terms of QASA. Again, it's a good question. In terms of once the scheme is launched, newly qualified solicitors on entry to the profession and in receipt of their practicing certificate will achieve level 1, will be automatically granted level 1 accreditation from 2015. So once we've opened up the scheme, we've got people in, any new qualified solicitors from 2015 will enter the scheme and automatically receive level 1 accreditation. It might, in terms of helpful documents to read, the rules and regulations have been approved by our board, and again they are part of the package of documents that have been sent to the LSB and is available on their website. A number of questions around the role of the judge in QASA, particularly in terms of if they haven't received the training that I mentioned earlier. If a judge has not received the training as part of the QASA scheme and hasn't received a unique identifier, then the judge will simply not be able to assess a solicitor as part of an effective sort of trial opportunity. Only those judges that have undergone the training, who understand the K form, have been subject to the equality, diversity and bias training, can judicially assess advocates in a live trial setting. And again, our systems here will be able to spot any judge that hasn't undergone that training. Another issue that's been raised is around ongoing monitoring. Again, at any point within the scheme, judges can submit a completed K form if they have serious concerns around the performance of an advocate. The present situation in regard to that is that a judge can contact us if they have concerns, or by letter or by email or by telephoning us. What we'll be asking judges to do now is to actually think about why they need to contact us in the context of the standards associated with criminal advocacy. So we think this actually strengthens the process and should hopefully mean that when we are contacted by judges, there's been a rational process to why they are raising a performance issue outside of a live trial assessment. Another question in terms of the role of judges is around how is the form passed to and from the judges. Well, the way we expect it to work is that obviously as an advocate seeking assessment within a trial opportunity, it's the responsibility of the solicitor to actually pass a blank case form to the judge. The judge will then complete it and hand it back after the trial to the solicitor. It will be the solicitor's responsibility then, in accordance with the IT systems, to upload that into the QASA system. I know there's been some debate around who should pass it back, and maybe judges not doing that, but as far as we're concerned, the judge should hand that form back to you. We're just working through these now. How will you know? We've had some questions regarding how will I know if the criminal advocacy evaluation form that I've submitted has been deemed competent or not. On submission of a completed judicial assessment form, you'll upload that into our system, and here at the SRA we will work out against the competency algorithm as to whether or not that trial that you've undertaken has been one that has been deemed competent or not competent. We will inform you through the IT system of whether or not it has been competent or not competent. It's worth pointing out as well that you're just not restricted to 2 trial opportunities. You have a maximum of 3 potential trial opportunities in which to demonstrate your competence. Go through these. In terms of a number of people have asked around registration deadlines, if they can't meet registration deadlines, what is the impact of that? The registration deadlines are in our rules and regulations, so we do expect compliance with those. However, if you're struggling to meet them for whatever reason, you're off on maternity leave, you're away from work, ill, or going on a very nice sunny holiday, then we can ensure that we can have a conversation around extending those. I've mentioned around the regulations, which are another couple of questions, and we'll make sure that they are put on the QASA section of the SRA website. A couple of questions around high rights of audience and what that allows you to do. You do need high rights of audience in order to be able to undertake criminal advocacy as defined within the scheme at levels 2, 3 and above. If you haven't got high rights of audience, then if you obtain them, it will allow you to undertake advocacy at those levels. Once, from 2015, advocates intending to undertake criminal advocacy at levels 2, 3 and 4 who don't have their high rights can undertake a high rights assessment that will involve the QASA level 2 assessment. So there won't be 2 separate processes. What we're planning on doing is amalgamating the QASA accreditation requirements in with the requirements to obtain your higher rights, so you'll automatically sort of kill 2 birds with one stone in that sense. In terms of the definition of criminal advocacy, this does exclude those advocates who undertake specialist criminal advocacy work. And I think the example that does come up through the questions has been sort of health and safety. Under the current definition, that will be excluded. However, if the case involves a need for a health and safety specialist to take part in that case, then we won't expect that individual to be QASA accredited. They'll be able to, as a specialist, be involved with that particular case. In terms of the independent assessors, again, we are in the process of recruiting a bank of independent assessors who will be able to be used in the scenarios that I explained. I think the important point with independent assessors is that they will have to undergo the same training in terms of that the judges have gone through, and they will be utilised at no cost to the advocate. So we'll be developing guidance as part of the scheme handbook, which will outline and be clear on the occasions in which an independent assessor can be used. In terms, this is a question from Heather, regarding the period in time in which to obtain judicial evaluation, can they be extended? We believe the 24-month period is adequate enough to obtain 2 competent evaluations from 3 effective trial opportunities. However, there's lots of circumstances which may prevent that happening. We will, again, as part of the process, extension process, be able to extend that in certain circumstances. We hope that will be, a flexible and proportionate approach to dealing with when any situations may occur. In terms of the notification exercise, which happened last year, that we've had a number of questions regarding the data that was provided at that point in time being different to a solicitor's current situation. That's absolutely fine. The information provided through the notification process was a snapshot in time. It was time limited. It was used for the planning purposes and helping us to test some of our assumptions. The registration is a separate process, and we'll ask a number of questions in relation to the level in which you're intending to practice advocacy. So don't worry too much if there is, your circumstances have changed. Again, a number of people are talking about delays to the scheme in terms of the Legal Services Board application. Our conversations with the LSB certainly, haven't given us that impression. And the reason why there's been an extension of time is that the scheme is incredibly complicated. There's a set of consistent rules across 3 individual regulators that all need to be tied together, and the paperwork involved with making that application and approval is quite significant. So we don't think there will be a delay on the launch of the scheme at all. Again, a number of questions, particularly from Robert, regarding the situation I mentioned around almost the passporting in of advocates. I think I'll just take a couple of moments to clarify that now. If you have obtained your higher rights of audience since 2010, then in recognition of obtaining that fairly recently, and there being a similarity between the assessment required to obtain that and some of the assessment required to be a level 2 trial capable advocate, and also to avoid us as a regulator placing a double charge advocate, we will passport in those group of advocates who've got their high rights since 2010 and award them automatically level 2 trial capable. Now, obviously that applies to you. If you want to be a level 3 advocate there or level 4 advocate, you can come in at those levels and be reaccredited through judicial evaluation in the normal way. If you've received your high right, if you obtained your high rights prior to 2010, then you will need to come into the scheme register and be accredited as per normal. A number of you are asking in terms of the costs of the accreditation, the assessment centre at level 2. We're in the process of putting together the tender for that piece of work, but as I mentioned before, we are incredibly sort of conscious that we can't, the requirements to attend assessment centre can't be a barrier to advocates entering the profession. So as part of that tender, we will build in the requirement that the cost cannot be prohibitive. A number of you, particularly Simon, are asking around advice and guidance on QASA. The slides that I've shown have provided an email address that is monitored by the team here and dealing with QASA. So if you have a specific query or need advice or clarification aspects of the scheme, that's the best way to contact us. However, you can still call the main SRA number and ask to be put through to the QASA team. Very good question from Julian regarding appeals. A solicitor will be able to appeal the outcome of their assessment, i.e. the assessment that we have deemed whether they are competent or non-competent in a live trial setting. That process will follow the overarching SRA approach to dealing with appeals, and again, as part of the scheme handbook, that will be clarified in detail. The process will follow the SRA's approach. A number of people are asking around, will advocates see the content of the evaluations that have been done by judges? Yes, if that is in response to an assessment opportunity, we're fully expecting the judge to be able to hand you back the form in order for you to upload, so you will be able to see how the judges assess you against the required competencies. In terms of ongoing monitoring, which I mentioned earlier, where the judge on their own volition can submit a form, we will take a view on whether or not we need to contact you regarding that. In the first instance, we will receive the form, we will assess the contents of that form, we will look at kind of regulatory history, we'll look at kind of performance within QASA, and if we feel we need to contact you, we will. I mean, if we don't, then there are very good reasons for that. Okay, I think that pretty much covers the majority of the questions and then the key themes that are coming through. As I said, we will be making more information closer to launch available on our website, so certainly keep looking at that as we move closer to launch. There is the QASA email address in which we will pick up any questions. In terms of next steps, we'll take all of these questions away and we'll put together a document and get that on our website, and hopefully if we haven't had the opportunity to answer your question today, it can be answered through that document. So just like to say thank you for kind of logging in, and I'm hoping that hopefully you now kind of understand the key policy changes to the scheme and how we at the SRA have tried to mitigate some of the unintended consequences of the scheme. So thank you very much and have a good afternoon. Oh, and the CPD code before EXT/SRA.